Hello there. Whether you're a seasoned entrepreneur starting your first venture, understanding how to protect your brand is critical today. So, I'm going to discuss with you the different options for when you file a trademark application. This is a question that comes up with a lot of clients. Do you file for the word mark versus a stylized logo versus a combination of the logos? So, let's dive in, and I pulled up from the US Patent and Trademark Office some trademark examples. First, there's standard word marks. That's just the literal element of a word, such as Under Armour, Twitter, finger looking good, just do it, American runs on Duncan. So those are just some of the basic standard character word marks, literal element marks, those are all interchangeable versus something like a logo trademark, which you could have a logo where it is just artwork by itself, or you could have a logo where it incorporates also the name of the brand. And here's a few more. You can say, Coca-Cola, that's a stylized version. Here's one where it's the stylized with the logo. I'm guessing here they were protecting how they show it on the can. And here's for Target, just for their logo. Domino's, it has the logo and the Domino's, and they filed for pizza pies. And then you have Ford for automobiles. So those are all the different ways that you could file. Now, picking out which way to file is where it gets complicated. Um, when we do a search for a client, depending upon what those results come back, will let us know what's available for them to file for and whether or not they can move forward with even using that logo or that word mark without infringing on someone else's rights. So when we're looking at it and trying to decide, something like the Nike one or the Domino's, which is what comes up a lot, is where clients are using the word mark as part of their logo. And they're always asking, well, if I file for just the logo with the word mark, does that give me more protection or not? And unfortunately, it's a very dependent matter. So in most cases, if the word mark is available, we'll generally suggest to a client that's what you should file first because that's what people ask for. That's what people do a web search for. That's, domain names would to protect those. That's where you get those protections from is through that literal element word mark. Now, that being said, is it also having the word mark when it comes time to renew a trademark application, you need to show how you're using it in commerce, how you've continued to use it. If you change the logo, you won't be able to renew that. Whereas if the word mark and you just file for the word mark, then it doesn't matter what stylization or font you use it in because you're just filing for just the literal element like these ones are here. Now, when you file for a logo, you also have the option to file for the colored version or black and white. And here too, it goes to being able to renew it. If you change the colors, if you decided to switch this, if Domino's decided to switch either the word Domino's to red or the, two-sided die, two-side piece to the red and then this to blue, they would not be able to renew that. However, if they just filed this in a black and white version, they would be able to renew it. So that's, a little bit about renewals. In terms of protection, which is really where a lot of clients' questions come from, is what is going to give them the most protection? As I said, with a standard character, just a word mark, it doesn't matter what font, color, anyone else uses Under Armour or Twitter, that mark is protected in connection with those specific services that they had filed for, or any likely. Or if someone uses a word that is similar, that would cause confusion, it protects it that way. When it comes to a stylized mark, in some ways, it really narrows your protection, but in other ways, it might broaden it. And that's always the hard part is it really depends upon who the infringer is. There's no yes, this is going to give you the broadest protection, or this is only going to give you narrower protection. It really depends upon who the infringer is. So it's hard. So in a good portfolio, you would have multiple versions. You'd have the standard character format, you'd have the logo version, you'd have the black and white color, and then you'd have the colored version as well. So why are sometimes the logos potentially broader protection is if someone came up with a different pizza place, and when you looked at this overall commercial impression, when you look at it quickly, the Domino's on the side, the word Domino's, there's a chance that someone can use a completely different word, maybe not even Domino's here, but because of the coloring, because of the shaping, it looks similar to Domino's logo, that they could be infringing, whereas if it was just the word mark, it would not be infringing. I don't know, maybe Doritos came up. It's not the exact same word, and then maybe they had like a shape of a Dorito or something there that looked somewhat like it when you looked at it quickly, and then they used the same blue and red. That would cause confusion, whereas just the word Doritos versus Domino's does not cause confusion. So this topic is something that comes up a lot with clients, especially because it's not a perfect world. Most clients, especially startups, do not have the funds to file every single version, every color of their brand, that they have to make a decision as to what makes the most sense. We generally say if you can go for the literal element, the standard character format, go for that first. But in some cases, that might be more difficult, or in some cases, the client really cares more about their logo. And then we have to decide, do we go for the color version or the black and white? So it's a very case by case basis. It's very something that has to be discussed between us, the client, what they're looking to protect. And just remember, you can always at a later date file for the other. Just you run the potential risk that maybe someone started using or filed for it before you that could cause some issues. But unlike patents, it's not that you lose the right to it. Another option to just remember is in certain cases, for the stylized versions, for the logos, it might also be possible to file a copyright for that. So you'll get some protection under copyright. It protects a different area than trademarks does. It actually just protects the artwork itself rather than the source identifying function that trademarks protect. So in some ways, again, it might give you broader protection. In some ways, it might give you narrower protection. It's all a balancing act. If you have any questions about this, feel free to reach out to us, jhrlegal.com. If you like the video, please press like below, thumbs up, and also subscribe to our channel. We're doing all videos like this. You can always feel free to reach out and let us know a topic that you'd like us to do one on. Thanks for listening and have a great